Judgment in the appeal Durkin and DSD Retail Limited and another.
Lord Hodge will explain the judgment of the court.
This appeal concerns a consumer credit transaction. In December 1998, Mr. Durkin purchased a laptop computer in PC World in Aberdeen. He wanted a computer which had an internal modem. The sales assistant, who was unsure whether the computer had such a modem, allowed him to take the computer home in its box and to return it when he found that it did not, or if he found it did not. Mr. Durkin paid a £50 deposit and signed a credit agreement, which the sales assistant gave him for the balance of £1,449. The credit agreement provided that the loan would be used only for the purchase of the computer and authorized the lender, HFC Bank, to pay the borrowed sum to the supplier, PC World. When he got home and opened the box, Mr. Durkin discovered that the computer had no internal modem. He returned it to the shop the next day, but the manager wouldn't let him reject the goods and took no step to cancel the credit agreement. That was the start of a long legal battle that has only now been resolved. Mr. Durkin refused to pay the money due under the credit agreement. In February or early March 1999, he spoke to an official from HFC Bank and told him that he'd rejected the computer and rescinded the sale contract and also the credit agreement. Later in March 1999, he wrote to the managing director of the company that owns PC World, complaining that the staff in the shop had refused to return his deposit and hadn't told HFC that the goods had been rejected. HFC warned Mr. Durkin that his failure to pay sums due under the credit agreement would damage his credit and that it would serve a default notice on him. In response, Mr. Durkin telephoned and reaffirmed his position. HFC made no inquiries about his claim that he'd rescinded both agreements, but issued a default notice and intimated to credit reference agencies that he was in default. Entries asserting Mr. Durkin's default remained on the registers of the credit reference agencies until 2005 or 2006. Mr. Durkin recovered his deposit from PC World in an out-of-court settlement, but that didn't remove his apparent obligation to HFC or the damage to his credit caused by the default recorded on the registers. He therefore commenced legal proceedings in 2004 against both PC World and HFC, asserting that he'd rescinded both the contract of sale and the credit agreement. He also sought damages of £250,000. In March 2008, the sheriff in Aberdeen held that he had rescinded both agreements and that HFC had failed in its duty of care to him. He ordered HFC to pay damages of about £116,000. PC World did not challenge the finding that the sale contract had been rescinded. Mr. Durkin appealed against the sheriff's assessment of the damages, and HFC cross-appealed on 3 grounds. First, it challenged the sheriff's finding that he had rescinded the credit agreement. Secondly, it argued that it hadn't breached its duty of care to him. And thirdly, it argued that the evidence didn't support 2 of the 3 heads of damage which Mr. Durkin had claimed. In June 2010, the First Division of the Inner House of the Court of Session dismissed Mr. Durkin's appeal and accepted each of HFC's contentions in its cross-appeal. It overruled a long-standing decision of a sheriff principal which held that Section 75(1) of the Consumer Credit Act 1974 empowered the consumer, when he rescinded a sale agreement, also to rescind the credit agreement which was tied into that sale contract. It held that Mr. Durkin had not established that HFC Bank had breached a duty of care to him, and that if he had established fault on HFC's part, he had not led evidence to establish his claims in damages other than the sum of £8,000 as general damages for the loss of his credit. It altered the sheriff's findings of fact to exclude his claims for extra interest paid and for the loss of the capital gain on an investment in Spanish property, which he said he would have made if his credit had not been damaged. After some delay, Mr. Durkin appealed to this court. In a unanimous judgment, this court allows his appeal. We agree with the Inner House's ruling that Section 75 of the 1974 Act did not allow him to rescind the credit agreement, but we hold that it was an implied condition of the credit agreement, which was tied to the contract of sale, that, if the latter contract did not survive, the consumer or the bank could rescind the credit agreement. Accordingly, Mr. Durkin had validly rescinded the credit agreement back in 1999. We also hold that HFC was under a duty to take reasonable care to satisfy itself that the credit agreement remained enforceable before it reported Mr. Durkin's alleged default to the credit reference agencies. It failed in that duty as it made no inquiries into Mr. Durkin's assertion that he had rescinded both agreements. Accordingly, it is liable to Mr. Durkin in damages. But in an appeal originating in the Sheriff Court, this court has no jurisdiction to go behind the findings of fact of the Sheriff, as altered by the First Division, on Mr. Durkin's damages claim. We therefore award only the £8,000 which the Sheriff had awarded as damage to his credit.
The court is now adjourned.